Okay, if you want to fix your attention to the screen, I have some instructions for everyone. Okay. Ladies and gentlemen, good morning and almost afternoon. I am Judge Kristen Simmons. It's my pleasure to welcome you to the 54A District Court in Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of the free society are asked to perform. Our system of self-government could not exist without it. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. Excuse me. One or more of these things could cause you to be excused in this particular case, even though you may be otherwise qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury may be chosen. If you do not hear or understand the question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving in a jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. I need all prospective jurors, both in the panel and the gallery, to stand. And raise your right hand. Okay, do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, you signify by saying I do.
I do.
Thank you. Let me introduce members of my court staff. To my right is my court reporter and judicial assistant. Her name is Ms. Addie Nash. And then to my left, the gentleman that helped usher you up here was Mr. David Warnsley. He's my court officer. This is a criminal case involving the charges of domestic violence, which I will explain more fully later. This charge has been made against the defendant, who is Jermonte Gates. The defendant's lawyer is Ms. Lauren Sutter. Ms. Sutter, if you can introduce yourself and list any witnesses you anticipate calling at trial today.
Good morning. Thank you everyone for joining us. I'm Lauren Sutter. I'm the attorney for Mr. Gates, who's seated right behind me. I know I'm blocking him a little bit. The intended witnesses we may call today are a couple of police officers and a gentleman named Gregory Kraft.
Thank you. The assistant prosecuting attorney leading this prosecution is Ms. Anna Buckingham. Ms. Buckingham, if you could please list any witnesses, of course, introduce yourself, and that you anticipate calling today.
Hello, my name is Anna Buckingham. I also want to introduce my co-counsel, Haley Fortuna Gill and Ross Marchmina. Today, we will be calling Officer Rebecca Hare, H-A-R-E, Officer Michael McGregor, M-A-C-G-R-E-G-O-R, Gregory Kraft, and Michaela Dominguez.
Does anyone in the jury box or anyone waiting to be in the jury box know of the defendant? If you do, raise your hand. Okay. Does anyone know the lawyers? Any of those witnesses' names sound familiar? Very good. This trial should last for just today. If you believe that the length of trial will be a real a real hardship, please signify by raising your hand. You believe it will be a real hardship? I'm sorry, I can't hear you.
Not feeling very well at this moment. I woke up with some intestinal issues. I'm not sure I can hold it the rest of the afternoon.
Okay. Okay, any issues with excusing him?
No, Your Honor.
You may be excused. You do still, however, have to report for the remaining of your jury service, okay, sir? I'm gonna replace him with, so seat number 1 is gonna be Matthew Barra. Thank you. Okay. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Or does anyone have an issue with sight or hearing? Can you raise your hand if the first part applies to you, that you can't sit for, if we don't sit for 2 to 3 hours, for longer than an hour? Okay, and then everyone can hear me? If you can hear me, raise your hand. How about that? Very good, so everyone can hear you. Okay, does anybody have an issue with seeing, it's a small courtroom, so you can see us clearly? Very good. Again, this is a criminal case. The paper used to charge the defendant in the crime is called a complaint. The complaint in this case charges the defendant, Jermonte Gates, as follows. On or about July 1st, 2025, at the area at or near 6338 Hilliard Road, Lansing, Michigan, that the defendant did allegedly make an assault or an assault and battery upon a Michaela Lee Zamatis Rethamel, a resident or former resident of his or her household, or an individual with whom he had a child in common, or an individual with whom he had a dating relationship. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think it is evidence of that he is guilty, or evidence of his guilt, or that he is guilty because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Bless you. We will now begin with Wadir. You may proceed.
Thank you. Hi, everyone. So this is the exciting part because this is the only time in the whole trial I get to talk to you. first, thank you all for doing your civic duty. I know a lot of you probably don't want to be here, but it's important to make sure we have a jury of peers for fairness, both to the state, but also to the defendant. So thank you for coming. We have to pry a little bit into your lives to make that determination of if you're the perfect fit. So if you are dismissed, please don't take it personally. We just want to have the perfect jury for the defendant. So my first question is by show of hands for all the jurors on the panel. Have any of you been on a jury before? No? No one? Okay. And next, starting with juror 7, can you tell me some of the ways that you would assess if someone is telling the truth? Do you have kids? Or do you have, like, can you think of a situation where you had 2 people telling you different things and you have to decide, I wonder who between these 2 people is telling the truth?
Kind of hard to find facts in there.
Right. Are there some things that have to do with demeanor or tone that you use to assess this person might be telling me the truth, they might be trying to trick me? You think of anything?
Not off
Not off the bat. Okay,
Yeah.
we'll go around. Juror 6, would you mind, can you think of anything you use to assess?
I look at body language, eye contact, the way they deliver their testimony, whether it's sincere or not, the voice, the tone, that kind of thing.
And when you say eye contact, can you elaborate on that?
It depends on if, what I mean by that is when they're being asked the questions, are they really directly looking at the person asking the question, or are they shifting their eyes in different directions?
Kind of darting around,
Yes.
avoiding, okay. And then juror,
I would say body language as well, and then consistency in what they're saying.
okay. How about you?
Really same thing, just content. If it looks like they're kind of searching for what they want to say, or not that they're trying to think or recollect, but kind of really telling, and, or if they're kind of guessing.
That makes sense, yeah. All right, and then we'll go to you.
Eye contact.
Contact, okay.
Like just body language, like if they kind of like take it, or avoid eye contact with the previous juror said.
Okay. And then juror 1, can you think of anything else? We have body language, eye contact. Anything you want to add?
Just consistency in their story.
See, okay, so that things at the beginning to the end just track and make sense. That makes sense. I'm gonna put a little bit of a spin on that. Can anyone think of a reason that someone might be avoiding eye contact or appear uncomfortable while telling the truth? Go ahead. Yeah. Go ahead, and let me get this straight in my head. 7654, juror 4.
Some kind of spectrum disorder.
Okay, so sometimes maybe if they have a disorder, they're on the spectrum, it might be difficult to make eye contact, that kind of thing. Okay, juror 6.
That's what I was gonna say, autism spectrum disorder.
Okay, and then did I see another hand? No. Okay. Do any of you have any experience with law enforcement that would make it difficult for you in this trial? And I ask that because, as I said at the beginning, we are going to have witnesses that are law enforcement. And so I want to make sure that we can kind of dig into that and see if that's something you're able to still be fair to both sides. I saw you raise your hand, juror 6.
My son is currently part of Explorers at LPD, and I believe, when I think of it, I think one of the officers that you mentioned, I think he did a ride along with.
Okay, and so was that a good experience for him?
Oh, yeah, yeah.
Okay, is that something that you feel like would in any way make you biased towards either side?
Yes, I'll be honest.
Okay, is that just a general feeling you have because you like law enforcement, or is that something where in this particular?
My dad is also retired from Michigan Department of Corrections, MDOC,
Okay,
so I honestly do have a natural bias, I'll be honest.
is that something that you are able to put aside in this case, looking at the defendant and say, I know nothing about him right now? And
No,
because of that,
honestly, no.
no, okay, so you're more inclined, how do you feel about officers and,
I will always believe the officer.
okay. has anyone had a unpleasant experience with a law enforcement officer? Juror, I'll pick on two for a second. When you are listening to an officer, do you feel that you'll be able to evaluate them the same way you would any other witness?
I believe so, like, because at the end of the day, they are just a person. So it's basically just listening to them speak the same way we listen to anyone else.
Right, and you'd be analyzing it kind of the same way we talked about with the same kind of traits, tone.
Yes.
Okay, and how about you, juror 3?
Yes, ma'am. They're people first.
Okay, and juror 3, have you ever had any interactions with the Ingham County Prosecutor's Office?
Kind of.
Okay, would you mind elaborating on that?
My son is on the spectrum and also has some mental illness issues. And when he was younger, when he was minor, we were trying to figure out if I should.
Okay.
Nothing was ever filed. I didn't directly speak with him.
Okay, did that experience in any way impact how you feel about the prosecutor's office? Okay, and then juror 4, have you ever had any interactions either with LPD or the prosecutor's office? Nope, okay. Juror 5. Okay, and then we already want to see you. Juror 7, have you ever had any experiences, good, positive, negative, with Lansing Police Department or the Ingham County Prosecutor's Office?
Not negative from them, but probably from me.
Okay, can you tell me a little bit about
I
that?
was arrested and
Okay,
charged with drinking and driving.
and how long ago was that?
That was back, I want to say, 07, 06.
I can't hear you.
I'm sorry.
You said 07?
07,
Okay.
06.
And is that experience something that you feel like would impact at all how you perceive either officer testimony or me, anyone from the prosecutor?
No, I still find trust in the police department.
You still
know.
find trust in
Yeah, oh,
them?
yeah.
Okay.
Yeah, for sure.
Okay,
That all was my fault,
okay.
you know?
So that's
So
something
I
you can-
don't, yeah, I don't have any, negativeness
Okay,
towards them at all.
okay. Let's talk for a second about one of the hardest conceptual things that even I feel like attorneys struggle with, reasonable doubt. We hear about it all the time. It is very hard to conceptualize, to kind of understand what's that threshold. Juror 1, can you do your best at just taking a stab at what reasonable doubt means to you?
I think,
And I won't judge you for whatever you throw
Yeah,
out. It's
yeah.
super hard.
right. I think just that maybe the evidence presented is not, we're talking about like not reasonable doubt, or just the concept.
Just in general, so what is something that you're able to say, I believe this to be true beyond a reasonable doubt? Just kind of, where's that threshold for you?
I think just based on the facts at hand, it's really just a gut feeling. It's gotta-
Okay, and then juror 2?
Like, if the evidence presented is not pointing towards a guilty verdict, then you have a reasonable doubt to suspect that they're not guilty.
So it's almost you're taking the doubt, and then is that reasonable to you to think that that would be a reason not to continue? Like it hasn't been proven to you? Is that kind of, okay. Juror 3, can you explain what beyond a reasonable doubt means to you?
That's gonna pretty much do what he said, that the facts, the facts are there, obviously. Facts aren't there. I kind of have,
Again, it's a hard
I
concept.
know what it is, but
Yeah.
putting it to words is,
You feel like you could feel it and know,
yeah.
I am convinced beyond a reasonable doubt. Okay, juror 4?
Yeah, so evidence presented is obviously, I think that the gentleman is currently not guilty, because I haven't been shown in the evidence. So if the evidence that I get, changes that.
Sure, I have anything to add that anyone
Yeah.
else hasn't said?
I can move on. That's okay. Juror 6, do you have any thoughts about beyond a reasonable doubt, what it means to you?
Just to know for sure that after hearing all the facts that you know, there's enough evidence presented to make a decision together.
I feel like you have to be firmly convinced.
Oh, yes.
Okay. And juror 7, do you have any comments to add to that?
It would really have to be in my gut and heart to know that that evidence is true. And without a reasonable doubt, that is what happened
Okay,
in that case.
that makes sense. Those are really good definitions because that is a hard concept. I'm gonna give, and this happens a lot, lawyers like to give analogies and examples. I'm going to give you what's called the evil twin theory. So let's say you're sitting on a jury and it's a homicide case. And you have been presented with evidence of GPS where the defendant's car was. It was at the location at the time of the murder. You have video surveillance of the murder occurring, and the defendant looks up at the camera. You see that it's him. So you have visually seen that. You get DNA evidence. You have his fingerprints on the body, on the weapon. You have the weapon. Now, let's say at the end of that trial, the defense decides to put on a defense and they stand and all they say is, members of the jury, the defendant is innocent. He has an evil twin. And then he sits down. Juror 6, is that doubt that the attorney put in your mind with the evil twin, do you feel that's reasonable, and why or why not?
That would be unreasonable to me.
Okay, why do you feel that way?
To me, it would just be like a last resort to try to get a defense.
Okay. And juror 7, how do you feel about that?
She took that out of my mouth. I was gonna say that as well. It's just, it's not enough.
Well, isn't it possible that he has an evil twin?
I guess anything is.
Yeah.
Anything's possible.
Is that possibility enough for you to sway your conviction of his guilt?
With all the evidence presented, possible.
Possibly. Okay. Tell me a little bit more about that. Why would you feel that might sway you?
Well, I mean, if he's right in the camera and we're seeing this act out, that's enough for me.
So you're saying that the evil twin idea would not be enough to
No.
sway you? Okay. Juror number 5.
Without evidence of the evil twin, no, that wouldn't sway me.
Okay. And go ahead. How do you feel about that?
Yeah, I wouldn't sway me either unless they present it to you between.
Okay. Go ahead.
I was gonna say the same thing. I would have to see proof that the evil twin existed.
Okay. And is that because you feel it's just not strong enough to negate what's already been presented to you? Is that kind of the thought behind that? Okay, juror 2.
So in this hypothetical, did you say that DNA evidence was already?
Yep, fingerprints were on the
fingerprints?
body. Mhm.
Well, I feel like that would be enough to like not sway me because like if the DNA evidence is proving it, then that would pretty much, be
Mhm.
a closed case because, twins can have two different kinds of DNA.
Sure. How do you feel about that?
I think the lack of, it's just a statement that there's an evil twin, and no further evidence.
Okay, that wouldn't be strong enough to. Okay. All right, sometimes when we look back on an emotionally charged situation, it's easy to become upset describing what happened. So we're gonna go juror 5. If a witness were to become emotional while describing a situation, do you think that you could still do a good job of judging the level of their truthfulness? What are some things that kind of would be going through your head in that situation?
I'm a bit of an empathetic person, so it would affect me, but it wouldn't
sway me necessarily. I wouldn't just go with that. I honestly think it would help me to understand better.
What if a witness was becoming angry? What would your thoughts be on that in that situation? What would you kind of look for?
Would depend on the context, the content,
Mhm.
of what they were saying.
Kind of what the tone is, why they're becoming angry
Yeah.
in that situation. Has anyone in this, on this panel ever been in, has anyone ever lived with a romantic partner after the relationship ended? No? Okay. Has anyone ever, how many of you, by show of hands, have kids? Okay, so juror 1, are you still with the person that you have to share those kids with?
One.
One of, okay. And how is your relationship with the other?
It's pleasant. We don't, our kids are both grown, so.
Okay, pretty amicable.
Yeah.
Okay. I saw another hand. Yep, go ahead and tell me about.
I've been married for 23 years.
Okay, all right. And juror 1, do you think that arguments between partners, this sounds like kind of a gimme question, but are they in any way different than how you would expect arguments between strangers to go?
I think so, and there's emotions involved and
Okay.
more than just more history, I guess.
Do you think that emotions tend to run higher in those kind of personal relationship arguments?
I think so.
And why, can you give me a couple of reasons why that would be?
Hurt feelings, things can bring up the past experience, you might have said something careless and then later on that can bring that feeling back. to somebody. They've said about something that's unrelated to what.
Juror 3, do you have any thoughts or anything to add to that? Anything you could envision why an argument between romantic partners or ex-romantic partners would be different than how maybe 2 strangers would be interacting?
Partners, ex-partners have an established relationship, so they really know each other. So the arguments are gonna be a lot more passionate than it would be with me.
Anything to add to that? Or-
Actually, it's the opposite with me.
Okay, go ahead and
Actually,
elaborate.
I would be more likely to be more passionate arguing with a stranger than I.
Okay, and why do you think that is?
Because my spouse and I have mutual respect for each other, and we actually, I'm not gonna lie, we have never had a major argument in our marriage.
Okay, lucky you.
I mean,
Alright.
little spats of disagreeing, but nothing that's a major argument, and so it's a level of respect and trust, and so I'm more likely to get mad at a stranger than I am my spouse.
It's more to preserve that intimate
Yes.
relationship. Okay. Juror 7, can you think of any reason that someone may not contact police if their partner were to, if they were to have a bad interaction with their partner and feel in danger? Can you think of any reason that someone might not contact police in that scenario?
Probably not to have a record shown on that, and probably don't want them to go to jail.
Hmm,
That's, if that argument is that heated
mhm.
with a domestic dispute. I just don't think that would probably be the wisest thing to do unless they're trying to work it out, but
Just to avoid kind of
trying
opening
to
up of that.
Open up a can of worms with that, and then get to the court.
Mhm. Juror 4, can you think of any reason that a partner might not call the police in that kind of situation?
Very similar, not wanting the partner to go to jail in court. I mean, you still care for that person. So.
Mhm. Juror 3, any thoughts on any other reasons you can think of?
Just not wanting to cause trouble.
Juror 2, could you understand a situation where there's a financial imbalance? And would that make sense to you of why someone would not call the police on their partner because maybe reliance, or do you have any thoughts about that?
I mean, it's definitely a difficult situation.
Tell me what you're thinking.
Well, until you brought up the financial part, I was thinking maybe also has like criminal history and doesn't want to involve police, or like the other jurors said, they don't want their partner to go to jail. They could potentially have some form of like Stockholm syndrome or something like that.
Juror one, can you think of a situation where a financial imbalance might impact whether a partner wants to involve police?
I think if the person that they want to call the police about is earning most of their living expenses, that could really make it.
Juror 5, what are your thoughts on what you just said?
I agree. When someone's interdependent on someone, putting them in jail is a risk to yourself.
Finally, this is my last question for all of you, the catch-all question. Does anyone feel there's anything in your own personal beliefs, experiences, backgrounds that would make it difficult for you to sit as a fair and impartial juror? Given, this is a case of domestic violence, can anyone think of it? Maybe I didn't hit a specific question that's kind of in your head, bugging you. Does anyone have any concerns about being able to sit as a juror that you would like to share? Go ahead.
I have a brother who was a victim of this violence.
Okay, can you tell me about that just a little bit?
Yes, he had a very abusive wife, and she'd be on him, and punch him and hit him all the time. But being he's a man, he's a Christian man, he would never put his hands on his wife because he didn't believe in putting his hands on a woman. But it wasn't just physical abuse, it was emotional and mental abuse. He actually has PTSD from it to this day.
Okay, how do you feel like that would impact you as a juror?
It makes me, I'm more sensitive to this topic. Like it would make me more heightened, more harder for me to convince it didn't happen than to not to think it did.
Okay. Does anyone else have anything? It doesn't necessarily have to be specific to domestic violence, but anything else that you feel might hinder your ability to be neutral as a juror? That's all I have. Thank you.
I'm gonna reiterate what my opposing counsel said here. Thank you all for being here. We know it's a lot for you to be here for a full day. It truly is one of the most important roles we can play in society. Something I've always wanted to do, and now that I'm as a practicing attorney, unlikely to be able to do. So I'm a little jealous of some of you, and I hope that you take it as an honor to be here. We're certainly grateful for you. I'm going to touch on a couple of things that Ms. Buckingham talked about. I'm also going to bring up some new things with you. She talked about the reasonable doubt being important, and she's absolutely right. It's deeply important. And she talked a little bit to some of you about what reasonable doubt might be. And there was some decent examples around of what some of you might be looking for. Can anyone tell me who has to show reasonable doubt? Prosecution? Talk more about that.
Since we're presuming innocence, the evidence from the prosecution is to prove beyond.
So you believe that it's the state who has to show everything here?
No, I guess I need to adjust my answer.
Sure.
Yeah, obviously, it's important to prove that out.
So do you believe it's the job of the defense to prove there should be doubt here? Does anyone agree with that statement? I've seen a couple nods, number 2 is nodding. Why do you think it's on the defense to show that there is a reasonable doubt here?
I think just to show their side of the case, to refute what the prosecution is presenting. establish that.
So let's say we're looking into the future later today, and I don't call anyone to testify. I don't put anyone on the stand. Would that be a problem for you?
No, not necessarily, depends on what other.
Okay. What if you were to hear from the judge, and I'm going to reiterate, it's the judge who's going to instruct you in the law here. It's not on either of us to say the laws. We can't do that. All the instruction of the law says will come from Judge Simmons here. If she tells you that it is not the job of the defense to show a doubt here, is that something that you can accept?
Yes.
Is that something that the rest of you can accept? Does that sound reasonable to you? Or fair to you? Do you know why? Can you tell us why that would be what the law says to do?
Presumed innocence.
Presumed innocence. Yeah, right. So as he sits here right now, Mr. Gates, I'm blocking him a little bit because I'm a big girl. He sits innocent as he sits here right now. It is entirely upon the state to show that he is guilty beyond a reasonable doubt. It is not my job to show that he is not guilty. Does that make sense? Sound fair to everyone? She talked about the example of the evil twin. And I don't know if any of you saw, I laughed a little bit here. I'm a twin, so it strikes me as funny. And my sister has joked her whole life that she is the evil twin. We're very different people. She's about yay tall. So we're not identical, right? But there are identical twins. I had a case a few years ago. This is an honest to God true story. It's a running joke in this building. In a courtroom across the hall, I had two clients, or rather I had one, my coworker had another. They were identical twin brothers. Their first, middle, and last names were exactly the same. Their parents honestly did that to them. And they both were in front of the court for various reasons. One for some assault cases, one had an expired driver's license. So expired driver's license brother shows up because the police bring him on the assault cases. And he stands there and tells us, I swear to God, guys, this is not me. You're looking for my evil twin brother. Do you think any of us believed him in that moment? Yeah, right? Of course not. That's insane. It feels insane. And then we checked into his story. He was telling us the absolute truth. We had the wrong brother. So in that case, we looked into something that gave us a reason to believe the evil twin brother story, right? What if he wasn't able to tell us anything? What if we had gone to trial with this wrong brother and the state had shown there's some DNA evidence because identical twins have the same DNA. I know a lot about twins. I've been part of several studies. They put on all this evidence and it looks like completely we got the right guy here, but there's still this person saying, no, I'm not the guy. You got the evil twin brother. You're the evil twin brother. What if there was a third person, someone not related to either of these two, who got up there and said, no, this isn't the person you're looking for. I can confirm there is actually an evil twin brother. This person does exist. It's not a crazy story. This person's real, and that's who you're looking for. Would that third person telling us that be something that would sway you to believe this kind of otherwise crazy story might be true? That is that the kind of information you would be looking for to say what normally would sound insane actually holds some water. So you'd be open to a third party telling you, no, I know what's going on here, and I'm going to tell you what I know is going on here. That would be something that you would be open to hearing and might sway you from what otherwise might seem a little crazy. That sound fair? Does anyone have any thoughts or opinions on that? I know it's a bit of an unusual example.
I want to know more about who that person is. But
Who the evil twin brother is?
no, who the
Third
person.
Who the third person is, and what kind of things would you want to know?
The relation, assuming to both of the brothers.
How it is he might
what
know
it
there
is
is.
Yeah, what it is that makes them different.
That's fair. Anyone else kind of agree with that?
Yeah, and possibly how close he is to.
Gotcha. You want to know just how strong it is that whether he
relationship
knows.
is.
Yeah, that seems fair enough. Everyone kind of agree with that? Fair. Does anyone have any different opinions from that? Would you still not be convinced of this evil twin brother story? And if it helps, I don't think anyone's saying that there's an evil twin brother that you're going to hear about today, but I'm using the example that was before you earlier. Okay. So you also heard Ms. Buckingham talk a little bit about relationships and tensions, right? There's high emotion sometimes in relationships. Do you believe that adults should always be in perfect control of their emotions? Anyone have any strong thoughts or opinions on that one way or the other? You look like you're thinking hard, number two.
I mean, it's should is kind of like the goal, but I mean, it's kind of inevitable to not have full control of your emotions during certain instances.
And what do you think a certain circumstance might be where someone's not in perfect control of their emotions?
Like if they get like overstimulated, with, like different things, just messing with their brain or something.
Anyone else share that thought or have a different thought?
Well, it depends on if it's a person that already has an established mental disorder or that kind of thing, then somebody is going to have different control of their emotions, but that would have to be established first. And but in ultimately, I believe most people are responsible and in control of their own actions.
Okay, so you would think people should be in control of their own
Yes.
actions all the time?
Yes.
Okay, regardless of what's going on.
Only if they have an established medical condition that would prove otherwise.
Okay.
Why?
Do any of you believe that there's ever a situation where physical contact might be justified? And I'm not talking about punch to the face. I'm talking about any kind of physical contact between two people.
Defending yourself?
Defending yourself, sure. Anyone share that thought? Self-defense, yeah. Any other times?
We're trying to prevent someone from like, the
Can you
child.
speak up a little bit, sir?
Yeah, sorry, like trying to prevent from somebody harming somebody else, like it's a child, for example, like.
Yeah.
One parent trying to hurt a child and one trying to get it to me.
Do you think it's fair for a parent to try and use some force to protect a child? No, that's okay. No, I want to hear your opinions. Absolutely. So you're saying a little bit about that, number one.
Yeah, like restraint maybe. I think that's good.
Restraint. You say restraint. So what do you mean by restraint?
Like maybe just like trying to make yourself a barrier between that person and the person you're trying to harm.
Do you think one person trying to move another out of a room where there is a child would be something like what you're talking about?
Potentially.
And then you had an opinion, number three. I'd love to hear more about it.
As a mom, I would put myself in front of my child. To protect them. As far as physically moving another person. Again, as a mom,
It's ingrained. Yeah, it's an instinct to protect, right? That's fair enough. Thank you for speaking up. We want to hear about that. So don't feel bad about the kind of outbursts. It means you have a strong opinion, and that's exactly what we're trying to get out today. She talked a little bit in the beginning, Buckingham here, about there is no wrong answers, and it's not your fault to be removed from the jury. We're not looking to see if you're a perfect person. That's a ridiculous request. I'm not perfect. She's not perfect. None of you are perfect. And God, what a boring world would it be if we all were, right? We're looking for the perfect jury for this specific case. So you're all great people. You might just not be what we're looking for here. Do any of you think that two people can be acting unreasonably at the same time? I'm seeing a couple of nodding heads from 4, 5, 2, 3. I'm seeing them all kind of around place. I saw you two first. I'm going to go number 4. You shook your head to that one I asked. Give me some thoughts on that.
Yeah. Two people can definitely be looking at a situation from completely different perspectives, and both of them think they're right in the situation, but obviously they're both not right.
And then number 5, you were also shaking your head.
Just emotions come to a head, and both people can easily be heated, and truth doesn't even matter.
And do you think if you use the word heated, I'm going to steal that word, if two people are heated with each other and acting unreasonably, what would you think of another person? I'm going to reference an earlier example of mine of one person trying to remove another from a situation.
I wouldn't think negatively of that. I think separating people that are being unreasonable would be a good thing to do.
What if there's not a third person doing them? It's one of the two indicated conversation removing the other from the space.
I guess it would be more information.
Sure, about what the removal was like, things
Yeah.
like that. Is that what you'd be looking for? Okay. Does anyone else kind of share what number 5 was just talking about? Number 3, yeah, you raised your hand. Let me know more about your thoughts there.
Just what you said, I would need more context.
And what he was mentioning before of it might be reasonable. Do you share the opinion with him that it might be reasonable for one person making an exchange to try and remove the other person? You want to know more about how the removal happened, but there is a world in which it could be reasonable. So I need to break that down into simpler phrases.
Kind of in the middle on that. I would just need more context on the situation. Like, how they were removed from the
Gotcha. So
situation. I would need more background.
So context matters.
Yeah.
Does everyone else agree with that? Context matters when it comes to how this exchange might happen and exchange might happen. Anyone got a strong opinion the other way about that? Or
The definition of unreasonable there is not even enough to really know. Depending on what that is, I might say yes, absolutely.
Yep.
Or I might say that was not justified.
Sure, yeah, okay. And I saw you had an opinion.
Yeah, if it's like the person trying to remove the other person from the room, if they're trying to de-escalate the situation, or if they're just trying to move the location for escalation.
Gotcha. So what if we have the additional information of there's a child inside the room? That change anyone's thoughts on one person removing another person from the room?
There's also the option of the person could just walk away.
Person could just walk away. What if,
Instead of having to remove a person, the person could just walk away.
what if that person's not walking away? They're trying to push forward.
Well, there's still ways you can remove yourself away from the situation. If you decide to push it forward, you can still remove yourself if you really want to remove yourself. Rather than go into that person, you should remove yourself.
Okay. What if it's your bedroom?
You still, if it's your bedroom, you still have to have enough kindness to say, okay, I need to leave my room, even my house, to protect myself in that situation rather than fighting back. Sometimes that logical thinking that should happen first.
Gotcha. Even when your child's in there.
I just take my child with.
Okay. All right. Anyone else have some thoughts on that? Agree or disagree?
I think it's you, the person, like she said, to remove themselves.
When you say the
Probably
person,
to-
which person?
Either one. To walk away, to de-escalate the argument. Than to stand there and have it escalated.
Gotcha. Okay. All right.
I might ask if the person that did the removal was worried for the sake of the child.
Sure. Would any of you, and this is kind of harkening back to something I talked about earlier, would any of you need both people in that exchange to talk about what happened? You would need both people, even if one of them is Mr. Gates.
Yes.
Do you all understand that he has no obligation to testify? Can any of you think of reasons why he might not want to testify?
You can tell the truth.
Okay, is there another reason?
Better just let your attorney speak for you.
Sure, yeah.
Not incriminate yourself.
I'm gonna use an example of my coworkers, steal from her. There are a lot of studies done by colleges in the United States, and one of the ones is doing a large survey across multiple age groups in the United States about people's number one fear. Any guesses as to what often comes back in that answer as to people's number one fear? Public speaking, you nailed it. 3, 4, and 5. Yeah, absolutely. Does anyone think that might be a fair reason why he might not want to testify? Anyone think it's, I'm seeing some disagreement from number 6.
Because if it's something as serious as this, you want to speak for yourself regardless of who you're speaking, so people would believe it being true.
So you would require him to testify in his own defense in
Yes.
order to believe what I am presenting as his lawyer.
Yes.
Anyone else agree with that?
I would disagree, just like we were talking about the previous round of questions. I mean, your body language changes if you're afraid, so you might start adding doubt. And the jury, you're nervous and not making eye contact, fidgeting because you're afraid.
Yeah, and we talked a lot about when Ms. Buckingham was talking about what you're looking for when you're looking for honesty, right? And I think a number of you mentioned fidgeting and eye contact. Some of you talked about that's a display in people who might have ASD. Are there other circumstances for people not with a mental health diagnosis who might have those fidgeting eye contact issues?
Social anxiety.
Social anxiety, yeah. We talked about dishonesty, what about fear? This is I don't know about y'all, but this is a nervous situation, right? We're in a trial here today. Is that a fair reason why I might suggest he not testify? Well, folks, I think for now that about wraps it up for me. Once again, thank you for all being here.
You have any challenges for cause?
Not for cause, Your Honor.
Any challenges for cause?
Yes, Your Honor, I think number 6.
Juror number 6. You didn't think that was a challenge for cause? You're objecting to challenge for cause? That's what I'm asking.
No,
Your Honor, I'm okay. not Because I think she made it clear that she has a bias, multiple bias. One being that she would believe the officer. The court rules and the jury instructions say you can't just give precedence to officer testimony over anyone just because they're an officer. She's also stated that because her son, I believe, did a ride along with one of the officers on this case, maybe. And then because she worked at the Department of Corrections, which I'm the former litigation manager for the Department of Corrections. So I don't know how that leads to a bias, or her father worked there, but that creates a bias for her somehow. I think there were some other concerns that I had even in some of the answers. I think the last question you may have asked as well creates an overwhelming sense of a bias. So I believe that she has to be excused. So we're going to excuse juror number 6.
Thank you.
And I'm going to put Gail Patterson in that seat. Any preemptories?
No peremptories, Your Honor.
And if I may just have one moment.
No problem.
You know, none at this time.
So with the exception of Patterson, you're satisfied with the other jurors?
Yes, Your Honor. I believe so, Your Honor.
Okay, you may question Patterson.
Hello, welcome to the hot seat.
No, I was at work.
Your hair looks great, you're fine. All right, you are now juror number 6, so we'll be calling you by that number. Juror number 6. Is there anything specific that we already talked about that you had any major thoughts on that you wanted to share? Anything that you kind of wanted, I have a thought, I want the attorney to know.
Yeah, that's a tough one for me because
Okay, can you tell me a little bit?
I'm so sorry. I didn't hear your
my
answer.
daughter at 18, domestic violence. It was really, really bad. She was 18 at the time. They were boyfriend, girlfriend. Things got out of hand. They ran apart. Really, really, really bad.
I'm sorry.
It was very difficult for her to press charges. I wanted her to, but she didn't. And then 3 days later, I found out she was back talking to me. And so we went back and forth, and then she started feeling like she would do it. And then about a week later, after the whole situation, this young man, he went out on the water with his friends on a boat. And the boat ended up flipping over.
Wow. Yeah, so this is kind of opening a wound of that whole situation.
So I have difficulty, even though now she's 23 when it comes to dating and who she's talking with. Because of all this we went through and then a death. Because I said some things to him like we definitely got press charges and we won't pursue this because it was that bad. And then
And is that something that you felt kind of put a wedge between? So she hadn't wanted to pursue that against him, right? Okay.
first she did more to do, she started doing she should, but it never.
Was that just kind of the cycle of the relationship that caused her to not want to pursue that? Is there?
So I didn't know things, but a couple of things had happened prior that she didn't tell me. That there's a couple of times he put his hands on her, but she never told. So I didn't know anything because when he appeared to be around me or at the house, he appeared to be a nice guy, a cool guy. But it was when I wasn't around or they're alone or they're with their friends and others knew about it, but I didn't. So it's very difficult for me.
Thank you for sharing that. I know that's super vulnerable of you to tell me. It sounds like that's one of the biggest situations in your life. Obviously, you love your daughter and it would be awful to go through that. All that being said, do you feel like you are able to separate that situation in this case? When I understand that you have your experiences, everyone does, different little triggers for everyone. Is that something that you feel like you can in your head separate that this is not my daughter's boyfriend, this is a different situation, and that you feel like you could still sit as an impartial juror, or how do you feel?
I think it would be difficult because I still have difficulty with it, even though, you know, it's still difficult for me when it comes to anything about violence. I feel like I've gotten better in therapy, but it's still a very touching subject for me. And I know everybody deals with it, but as a mom, very, because I automatically, when I hear anything or my friends or family dealing with a situation where I am a woman or she getting pushed around, you know, or anything like that, then I have a hard time with it, as I'm still trying to deal with this COVID.
I don't think I have any more questions for you, but thank you for being so vulnerable.
For being here, I know this is kind of tough for you. You're obviously emotional. If you need a tissue or anything, please. There's a bunch of boxes everywhere. And I'm sorry that's something your family has gone through. And so are you letting us know that you think you're going to struggle today to kind of set aside your own personal experience with what you might hear?
Yeah, I think I would. Just because how it all for that time of them being together, I didn't know.
Yeah.
And then for that to happen, then for him to.
It's a lot to weigh on your mind, right?
Yeah.
And you said your daughter was 18 when it happened.
Say what?
You said your daughter was 18 when that was going
Yeah,
on?
it was,
So it was about,
she was 18.
so it was about 5 years
Yeah,
ago.
5 years ago.
I'm really sorry that you're really tough with that, your daughter especially.
18, almost 19. It's pretty bad.
Oh, I'm very sorry about that. I'll leave you alone with that since I know that's the source of it. If it's okay, I'm gonna ask kind of one question here. Harkening back to the beyond a reasonable doubt stuff. If
No,
it-
we're only questioning,
Okay.
we're already done with that.
then I have further.
Okay, number 6. When you say that it could be difficult for you, I'm trying to get clarity. Is it difficult for you to be fair and impartial, or is it just emotionally triggering for you to hear the information?
It's a little bit of both.
Okay.
A little bit of both, emotionally triggering for me. And then fear, like, when it comes to certain things because of.
You
what-
said fear?
Yeah.
You would be in fear?
No, I said.
Oh,
fear.
fair. Okay, that's what I'm trying to get at.
Yeah.
Okay, I think that there'd be an issue with cause, correct? No objection. Okay, we're gonna excuse you, ma'am. And replace that seat with Amanda Paul. You can question juror number 6.
Hello, juror number 6, welcome to the rotating seat. We kind of get stuck in it sometimes. I'm gonna start out the same way. Was there anything generally that kind of piqued your interest of any questions asked previously that you'd like to just open-endedly talk about?
Actually, domestic violence is my own, so.
I'm sorry, couldn't hear you.
I recently have had a domestic violence case of my own with a gentleman, and so kind of like the last person, it was really hard to like try to be fair when you've kind of been through it and kind of like have that little bit of, you know, not knowing just because it's like just sitting here like shaking, you know, like just hearing what they have to say and then just bringing back all those memories with the PTSD, in which I've been diagnosed with as well for the situations I've been in.
Do you mind, you said you were diagnosed with PTSD. Do you mind me asking when that situation was occurring?
That was roughly 8 years ago. And
Okay.
I'm still on medication.
Yeah.
I still take daily medication.
So for kind of the anxieties of it, and
Yeah.
I'm sorry to hear
And
that.
I still do really bad paranoia. But, you know.
And in that situation, was that with kind of a long-term partner? What was the dynamic between you and that person?
It actually occurred as friends. We were trying to help another friend in a time of need, and then we ended up thinking that our friendship was getting closer and closer, and it gradually turned into about a year span. The first 6 months were good, and then he isolated me, moved me away from my family, and eventually the abuse physically started within that time. It was so about roughly a year before I finally broke free. I lived in a home women's shelter with my 2 kids for about 2 months until I could get housing and get on my feet. Such.
Thank you, ma'am. Counsel? I don't think we need to go any more detail into her personal life at this point. I think that's enough for us. Thank you. You can be excused. Let's see. I'm nervous about, let's see here. Carl Grace. Okay, question number 6.
Oh, juror 6. Good, how are you? Good. Where do you work? Tell me a little bit about yourself. We're gonna start out a little lighter.
Okay. Mailman, letter carrier.
I assumed, but I didn't know if it was a fashion choice. Do you like that job?
It's a job.
Yeah. How did you end up there?
My ex-wife.
His voice dropped off. I couldn't hear. I have a fan going right
I'm
here
sorry.
too, and then there's this plastic.
My ex-wife's father was there for several years, so she got it now.
I've heard it's a good job and
It is a decent
good
job.
benefits, and yeah. Do you like kind of this, do you have a lot of social interactions through it?
Sure.
Yeah. Is that one of your perks of it, or do you kind of not like that?
I think it's a perk.
Yeah.
I think it's a perk.
Cool.
Lighten the mood. I like the question.
Well, now we're gonna drop off. Juror 6, is there anything that we've already spoken about that you feel like we should know about? Feelings on any of the questions, any?
I really don't want to say, but my father used to. He's deceased now, but not forget.
Yeah, did that happen kind of all throughout your childhood or?
No, she.
Okay. Okay. Do you feel like that experience is something that you're able to set aside in this case? Knowing that the defendant, it's a different situation. How do you feel about that?
I mean, I probably could say.
Would you mind saying that louder?
I'm sorry. I said I probably could set it aside.
Okay.
Yes.
And in general, what are kind of your feelings about when you heard that this was a domestic violence situation? Did you have any knee-jerk reactions? No.
No.
Okay. Did you feel pretty neutral about the type of case it was, or
Yeah.
were you disappointed at all that it wasn't a different type of case?
No.
No.
Not at all.
Okay, but you feel like you could. You said you do feel like you could set it aside if
Yes.
you. Okay.
Yes.
How did you feel about the evil twin theory question? Did you have any thoughts on that?
It's possible. It's
Yeah.
a possibility.
Is that possibility enough for you to feel like it would negate all the other evidence that in that?
No.
No? Why is that?
Evidence is evidence.
I have a follow-up question on that. Is the possibility, is it reasonable to you
Is what reason?
that there could be a evil twin?
Yeah, it's possible. Yeah. Oh, yeah.
I ask that because most people don't understand what reasonable doubt. Most people would have no
All
clue
right.
what reasonable doubt is.
I know.
If you have
He
a
gets
doubt,
it.
you can have the
Just how
doubt.
he gets it.
You can have the doubt, but you
No.
have to ask yourself, is this a reasonable doubt?
Right.
Do you feel like you are able to set aside, so you get those instructions from the judge, you've read the instructions, at the end, there will be instructions. If you feel like there's anything conflicting with what you feel, are you able to set that aside, knowing the judge is instructing you on the law?
Yes.
Yeah. Okay. No further questions, you're on.
A little bit on the same thing, try and ask it in different things. So you think you would be able to not put yourself in the situation of what you're hearing today?
Yes.
To be able to completely listen to this as a new and different story than any prior experience you have.
Yes.
And you do think if you're hearing enough information about it, that it is reasonable that an evil twin theory might actually be true.
Yes.
And if that was what you thought, what would your verdict be in that case?
I'm not sure. It's kind of hard to say.
So if you think that the evil twin theory is possible and it's reasonable that it's possible, would you be comfortable if the law tells you then the verdict must then be not guilty? So if you sit here today after you listen to all of the evidence and you think to yourself, it's probably true that this happened, what would your verdict
If I feel like it's probably true.
be? So it's probably true. What would your verdict be?
Yes. No, because it has to be beyond reasonable doubt. So
So you're comfortable that the law tells you if you only think it's probably true, you still must give the verdict of not guilty.
yes.
Any challenges for cause?
In your honor,
Don't believe for cause, Your Honor.
Any preemptory?
no peremptory.
If I might just have 1 second. No, I don't believe there's any peremptory challenges at this time.
Okay, looks like we have a jury and panel. I apologize to the rest of you all that you all didn't get an opportunity. You seem severely devastated about it. And what I do wish for you is that one day you do get the opportunity. It's an amazing experience. I know it's annoying to get called in. Sometimes you miss work. You got to find childcare. I've served on a jury like Ms. Sutter long before I became a lawyer. Once you get to this side, they don't pick you anymore. I think in the last year I've been sent over there for jury trial twice and they sent me home both times.
I had it last week.
For that second time, they found out I was downstairs and said, you can send Judge Simmons home. So we no longer get chosen, and we can't do this without jurors that are willing to be open-minded, fair, and impartial, giving both parties an opportunity to tell the story, and then you make a decision based off that. So I appreciate you coming today in the bad weather. Obviously there was consequences if you didn't come, but I appreciate you being willingly participating in this. And I'm going to release you to our deputy court administrator for further instruction. For those of you all who are going to be impaneled, I'm going to give you some preliminary instructions, and then we are going to break for lunch after those instructions.
Yeah, and maybe approach just briefly in a preliminary.
Yes.
See, I know Susie's had my ADA combinations for like a year.
No worries.
Thank you.
Okay, I am going to give you a brief 5-minute break because it has been over an hour. You do need to stretch. It's hot in here, and some of you may want to use the restroom. In the jury room, there is a restroom in there. Those of you who are wearing or carrying your coats can leave your coat in the jury room. You're only going to be in there for 5 minutes, and you're coming back out here for the instruction. And then I do have to advise you that we do have someone in the courtroom with a severe allergy to mint. So if you can avoid any mint, if anybody had mints or anything, avoid it for today. Thank you. All rise for the jury. Okay, we're in recess for 5 minutes. Yeah.
I'm gonna get food. Or I'll die.
Thank you so much.
No problem.
Sorry, she's gonna ask. She's taking all of it.
You're not welcome.
Okay.
You're not welcome. Huh?
That's what.
That's how I feel about
I'm sorry, I got two.
I know they both would. I got his word. Yeah, you're good.
Yeah.
Officers were pretty separated.
Oh, no, they were.
So that everyone. Oh, gotcha.
Yeah.
Okay.
The other ones, everyone's just sitting around outside of there. She's in.
All right. That's a big one. That's a big one.
I think so.
Morning, did you? Can't believe you're leaving. Can't believe you're gonna leave me here. Oh. It's not my trial.
Yeah.
Yeah, every time
No.
I just think it's so funny. No, been there, done that, won't do that again. Not a chance.
What? Yeah, she can have a right choose.
Oh, they can come in like you just. Update, she's evicted. She could have come in if she wanted, apparently. I mean, okay, just like.
Oh,
yeah,
absolutely,
yeah.
yeah.
Okay. I didn't know, that's what I was saying.
Oh, no, I wasn't saying that she wasn't allowed to.
Gotcha, okay. Just generally for the sequence. Yeah, I'll see you guys.
Sometimes one of those weird things with like,
Yes.
sometimes they get weird. Yeah, they used to sit next to the yeah, I also looking about, I think you requested sequester witnesses for something, and then they haven't. This is the witness. The other one. You need a drink or anything?
I'm sick.
Oh, why is it live, Mail?
She was wild.
Oh, that was before. I'm scared.
I want you to do this at least a half hour for lunch, because my sandwich is on front.
We're gonna get at least a half hour. I gotta make it to Jimmy John's in Backthorn.
Good for
I'm
good
ordering
luck.
right now.
Jimmy, I want to know what happened to their old slogan, you know, because they're not. Tyler Smith is always trying to order delivery. When we work in the Knapp building, he's always trying to get Jimmy John's delivered. That man was sitting there for 90 minutes waiting for the sandwich.
Yeah.
From a block
If
away.
you do it through a third party, like Uber Eats, forget it.
Usually directly through the store. It's
Yeah.
that classic, that older guy on the Jimmy John's bike.
Yeah.
It's the same guy, yeah.
Jeez.
Yeah, not freaky fast.
What's our chin?
Is that your last one? Sorry, I don't know.
Oh my
Person.
God,
Okay.
yeah. He ran a
just
city
like,
trial probably in December. And
I'll just.
they actually got back on record to start that trial. Yeah.
And then everything on.
Yeah. So we got.
Yeah, if they try to hurry
It
up.
shouldn't be fast.
Yeah, I feel bad because it's like 4 witnesses.
Yeah, you should. We don't need to call him.
I don't have to.
No, I mean,
Yeah, I can just cross it next week. You guys want. Right. There's not.
He's told the same story every person.
Don't I know it?
He's been trying to keep listening.
Don't I know it?
I listen, I mean, he showed up right.
There weren't any
existed.
kids in the house. No, yeah, he's committed. I know, he didn't see them.
Oh.
We'll get into it later, everybody.
What?
We don't need a pregame trial.
I'm not pre-gaming.
Just wanted to comment.
Is she doing the bond violation? Is she? Was full. Required. For what? Doing it with the officer's body cam.
She ordered him.
The judge ordered.
Yeah, on the record.
I understand, so.
Alright. Friday, which is a Monday, the Friday before. The people to pray for something, before he changes the screen. review and.
Oh, that's because of the text. I wasn't focusing on that. I was. We're focusing on the house contact. 2,000 feet of residence. The first, and then isn't on the door.
I can keep it everywhere. Oh,
It's from the trial footage. It's 7-2. It's McGregor's body.
Oh, this one?
Yeah,
Yeah,
it's
I've
right
been
behind
there
the
a few times.
courthouse.
Yeah. What are the
Yeah. I have to wear a blazer, it's so hot.
It's so warm.
So now the fire version.
Oh, it's just whatever's oldest. Are you sure?
Yeah, I just.
It'll start to not be a problem because the judge says what's on their priority, like at the time of free trial. Obviously, if you want very much doing that.
Yeah, I know. Like I'm trying not to say it, but. So, it's scary.
I don't think they're gonna do. You more are gonna be out keeping the bar. I'm gonna be out with the baby. Heavy Pepper's gonna be out with the baby. And Adam's gonna be out with the baby. Within very close. But it's not the problem. That is not my job. Let's talk to Nikki about it. You said she has to interview this week. So then everyone will be ready to go. Okay.
Well, it was the government.
Yeah.
It's what she says, just. She said that at the last hearing, the judge said that I needed to take a note or something.
where do you have the actual bond violation that's supposed to be set for today? Yeah, it's, but I can't even. It would all be hearsay, so that the text between them, I don't know what you can say anyway, so it can have been. And then she probably wanted to take part in it, but the only thing I like is when the person wanted to be signed. We'll just see what she says. Ready for my second one. So let me read this. Yeah. So next thing yeah. Why is it weird? This is a lot of content, so I thought it made sense. Oh, you mean no? Officers in the area. I think it might be hard to follow because I probably would just because these stories can be hard to follow. The other witnesses are good to go. We just don't know what time she wants us back yet. What do you think the officer? I don't think it really matters. A ton. Like I don't think it's as huge of a decision. Then, like, I feel like a second. And then who's third? What do they add to anything?
We just have the probation violation hearings. Oh, right next.
Oh, let me go ask her real quick.
Okay, I got somebody outside. It was Keith. Okay. Okay. Just let me know.
Oh, they're not these. Yeah. So it's an old benefit. Covered this.
900 degrees up there.
Yeah. Who's here? Keith, what are you- That's a big win. Take it from right now, I think.
Oh, he's gotta get it right now.
Yeah.
I need the file.
What?
Remove your hat, please.
Are you saying one A or A1? Which, like, you know, doesn't matter. I don't think it matters. I would do one A because it's spring, but. Okay. Why are they wanting to do C? Should it be like 1, 2, 3? Just do the letters of all. We're not done.
On the record in the matter of the people of the state of Michigan versus Keith Wimberly, 24-03424.
Yeah.
Dear Mr. Keith Wimberly.
Yeah.
Okay, Mr. Wimberly, I have here a request and summons for probation violation. The allegations are that you committed the following technical violations that you have not tested since November 20th, 2025. There's also non-technical probation violation alleging that you've essentially absconded from probation and that you have not reported to probation since November. So you have the right to be represented by an attorney, and my understanding is that you either were in the middle of doing an intake or you're about to do an intake to the public defender's office. You have the right to have an attorney represent you at any contested hearing of this violation. If you're found to be in violation or absconding from probation, you can be serving the rest of your sentence in jail. Do you understand that? Did you want to request an attorney? Okay, the court's going to enter a not guilty plea on your behalf. We're going to set this for a hearing.
February 17th at 1:30.
February 17th at 1:30 is the hearing date. What's your phone number? Okay, did you complete your intake yet, or you need to go back and do it?
You still have to do that.
Okay, do you have any questions at this time? Okay, you need to check in with your probation officer before you leave here today, okay? Okay, you can continue to meet with Ms. Straub, and then we'll get you your notice for your next court date. that in? You can be seated. She's not on the back. Okay, no, I don't think she will. She has a case. It's for March 2nd at 1:30. Today's for Mm-hmm. Stephanie Lorowski. Can you hear me?
Yes.
Your court date's not for a month from now. March, I think it's March 2nd.
March 2nd. But can I ask you a question too?
I'm getting some feedback, so I'm not understanding what you're saying.
I'm saying, can I ask you a question real quick?
Yes.
Okay. They said long as I turned in my community service, I wouldn't even have to go to court. I just pay my fines. Am I right?
Who represents it?
I did all my community service.
It's an open e-hub. Open e-hub. Yeah. They might have given her something. I don't know what the files say. I vaguely remember someone getting something like that from the city. Can you pull her file?
This is
Stephanie Lorowski.
March 2nd.
March 2nd. Yeah, it does say if you complete 8 hours of community service, that's acceptable to the prosecuting attorney, that they will amend the charge to a civil infraction, breach of the peace, and your fine would be $135. So you need to contact your attorney. I'm sorry?
And I don't here.
I'm sorry?
Oh, never mind. Okay, I have his number.
Yeah, Mr. Yang, contact Joseph Yang, make sure that he knows that you've completed your community service. You just want to accept responsibility to the civil infraction, and then he can coordinate that with the court so that you don't have to appear in March, okay? I can't hear you, it went out, okay, ma'am? No, we don't have any sound from you. Okay, I'm gonna remove you. You need to call your attorney, okay? Okay, I apologize for that interruption. I think there's gonna be a jury instruction about that action. Okay, let's get this up on the screen. Okay, if you want to pay attention to the screen, I have some procedural instructions for you. Okay. Let me go back. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now have you stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If all the jurors could stand, please, and raise your right hand. Do each of you solemnly swear or affirm in the action now before the court, you will justly decide the questions submitted to you, and that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence produced and in accordance with the instructions of the court? If you do so, signify by saying you do.
I do.
Thank you. You will get a written copy of my instructions, but you won't get them until it's time to deliberate. You will then be able to refer to them. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of the trial, I will again provide you a copy of the final instructions to use during your deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First is the elements of domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with domestic violence. First, that the defendant either assaulted or assaulted and battered a Michaela Lee Zemitis Rethamol. A battery is a forceful, violent, or offensive touching of a person or something closely connected to him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Rethamel's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery upon Ms. Rethamel or make Ms. Rethamel reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery, or must have appeared to have that ability, or must have thought that he had the ability. Second, that at the time Ms. Rethamel was, you would choose one of the following: either the defendant's spouse, a former spouse, they had a child in common, was a resident or former resident of the same household, or the defendant was a person with whom, the victim was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent intimate association primarily categorized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The definition of use of force as or use of force and violence is used in these terms. As used in these instructions, the word force and violence means any use of physical force against another person so as to harm or embarrass him or her. A definition of touching: for a battery to occur, the touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Rethamel's will. It does not matter whether the touching caused an injury. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that's based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where she will give her theories about the case. The defendant's lawyer does not have to make an opening statement, but She may make an opening statement after the prosecutor makes hers, or she may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects, or possibly videos. The defendant's lawyer may or has the right to cross-examine the prosecution's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence in the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in the trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender or gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted as evidence, and anything I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests it is. I may ask some questions of the witnesses myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask questions. You should wait to ask questions until after the witness has finished in testifying and both sides have questioned or finished their questioning. If you still have an important question to ask, do not ask it yourself. You will raise your hand. You will write the question down and pass it to my court officer, who is going to make sure that you have pen and paper when you come back from your lunch. And then he will give it to me. Do not show your questions to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, or obviously while you were in here, there may be other, let me go back. There may be other matters that I have to take care of that have nothing to do with this case. Please pay no attention to those interruptions. You must not discuss this case with anyone, including your family or friends. You must not discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop, explain that you are a juror and you are not allowed to discuss the case. If they continue, please leave and report the incident to my court staff as soon as possible. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth and lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on televisions, radio, internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group and under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about this case by any means, including cellular phone or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff immediately. Again, you may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. As you can see, we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw a name to decide which one of you will get dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and to not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Do we know when to get in? Do we know?
Oh, I haven't gotten the word yet.
Okay, well, we might as well continue to opening statements then. You can make your opening argument.
Thank you again for sitting through all of voir dire and being willing to give your attention to both me and Mr. Gates in this matter. As Judge Simmons mentioned in your instructions, this case is about domestic violence. This case is about a moment where an argument crossed the line from verbal into physical. On the evening of July 1st, 2025, Michaela Zamatis and the defendant, Mr. Jermonte Gates, were no longer in a relationship. The relationship had been on and off for years, and they had broken up no longer than a few weeks before this night in question. Despite their current relationship status, they were still living in the same house under the same roof with a shared son. Arguments can happen in relationships, and breakups, along with living with the next partner, is difficult. You will learn that on that night, Michaela and Jermonte Gates were bickering, and once Mr. Gates arrived home, Michaela went to his room to try to figure out why he was acting the way that he had been that day. You will learn that Mr. Gates had enough of Michaela's nagging, and rather than continue the discussion, he got up and shoved Michaela. Not once, but twice. He used his hands to grab and push her with enough force out of a doorway into the wall across the hall. You will hear testimony that Michaela, stunned by this interaction, got up and walked back over. She had never previously been physically assaulted by Mr. Gates. She was a bit in shock with this interaction. She got up, went back to the door that Mr. Gates had shut, opened it to ask, what was that? And was grabbed again and pushed harder this time. She was shoved again into the door on the opposite side of the hallway. You will hear Michaela describe this incident. You will learn that the contact made by Mr. Gates was not warranted. It was unwanted and forceful. You will also hear from Mr. Gregory Kraft, who is the stepfather of Michaela and Jermonte's roommate. He will tell you that he was on the couch in the living room at the time, and you will hear that he observed Jermonte shoving Michaela. You will hear from police who met with Michaela and Jermonte and observed bruising on Michaela's upper arms. You will see photographs taken of these bruises and of a burn-like scab on the top of Michaela's hand from the incident. You will learn that Mr. Gates himself admitted to Officer McGregor that he pushed Michaela. No matter how it's framed, moving her, pushing her, it was unwarranted. Labels don't change the actions, and you'll see that the injuries will speak for themselves. This case isn't about who owns the house, how bad the injuries were, who paid for what, or who was nagging whom. This case is not about parenting time or living situations. This is about whether Mr. Gates intended to commit a forceful, intentional, physical, offensive touching of Michaela Zemaitis against her will. And at the end of the case, after you've heard all the evidence and the judge instructs you of the law, we are confident that the evidence will show you beyond a reasonable doubt that Mr. Gates is guilty of domestic violence. Thank you.
Yes, sir.
Afternoon, now, I think. Well, good afternoon. So we thank you all for your time and attention here today. I expect you're going to get a lot of information dumped on you throughout the course of the afternoon. State's certainly telling you that you're going to. I'm expecting that you're going to. And we ask a lot of you at the end of getting all of that information dumped on you. But what you do here matters very, very much. Now, as for what you'll hear, we've heard a little bit of what the state thinks you'll hear. They think that you'll hear that Jermonte shoved Michaela. You may hear that on the day in question, Jermonte came home from work late in the evening. He went into his room. His young son was asleep in there. Their shared son was asleep in that room. You will likely hear that Michaela came into the room to have an argument, continuing bickering from what was going on earlier in the day. You'll hear that she was frustrated with him. She went into his room. She went into him again. You'll likely hear that he told her firmly she could not be there. She needed to go. It wasn't her room. It was late. You'll hear that she ignored those requests. She repeatedly came back in the room to try and have an argument with him late at night. He was trying to sleep with his son inside the room. This is not a case of anger or violence. This is a case of a young man trying to set clear boundaries and protect his personal space as well as the peace and safety of his son. Again, this is late at night. Jermonte and his son are trying to sleep. Michaela is repeatedly entering his room to have an argument. We often hear the phrase, the truth is somewhere in the middle between two stories, right? We don't often get to hear the story from that middle perspective. I think you will today. The state mentioned here Gregory Kraft. He was there that night. He was there asleep on the couch, not that far from this whole incident. He will tell you that he sat up from where he was on the couch and watched the whole exchange. He will tell you exactly what he did and did not see that night. The state will try and show you in movies. You'll see the pictures. They are not at all going to match up with the story they're going to tell you goes with them. There's a reason for that. At the end of this trial, when all of the evidence is presented and all the witnesses have told you their stories, I'm confident that you're going to believe there's some reasonable doubt here as to whether or not the story the state tells you is actually true. And if you don't believe that that story is actually true in the way they tell it to you, and if you have any hesitation in your mind about whether or not that is the truth, that is what actually happened that day, then there is only one fair and just verdict that you can render. And I do think that's the conclusion we'll see you come to today. That would be not.
Thank you. I believe that our your lunch is here. So we are going to recess so that you can have lunch. And that also gives me an opportunity to take care of something off the record. And then You're going to get you've already got your stickers. Okay, good. That devices your juror. You've already heard instruction and that you're not to have discussions with anyone that may be connected to this case. So you have to be careful because you don't know who's connected with the case. So you'll be in the jury room. There is a restroom there. If you need anything else, you'll just let the court officer know. They'll make sure they'll get what you need for you. Again, you can leave your things in the jury room. You're the only one who has access to it at this point, okay? All rise for the jury. Okay, we're going to recess until 2:30.
I think